Good afternoon.
So before lunch I was dealing with the language of the provision, and I'd made my submission that there were pointers in the language, but we didn't think it was dispositive, that the text was somewhat Delphic, and that was effectively the approach adopted by the judge, who said it came down to a question of implication. OFWAT set their stall out very much higher in their skeleton argument, page 49, paragraph 30. And I should say this is consistent with paragraph 29 of the SGR and 30 of the DGR. Their case is, the meaning of this sentence is not ambiguous, and effectively the language makes it clear that it's intended to grant a discretion how to respond when OFWAT receives...
I'm sorry, I'm just slow to find the reference. Tell me again.
It's page 49 of the core bundle, paragraph 30, under the heading Natural and Ordinary.
I'm there now, thank you. Right, so their first thrust on this is natural and ordinary meaning.
Yes, now, here begins the very many instances in which OFWAT advance an approach that's completely different to the approach of the judge. And they say, effectively, and this recurs throughout their skeleton afterwards, it's the answer to many of their points, but the language is plain, etc. Here's the beginning of this analysis. Their first point is, the starting point is that performance is assessed regardless of considerations of fault, no fault. Well, that's perfectly true. That's the first paragraph. It doesn't address the contents of the second paragraph, which is what we're arguing about. Secondly, they say the company has a procedural entitlement in the case of a civil emergency to make representations. But you have my point, that doesn't take matters anywhere when we could decide it's not worth the candle or what have you. And what's more, making of representations and grants is equally consistent with OFWAT, as is common ground, having to decide whether there is a civil emergency and whether or not it's caused by the civil emergency or our fault. That exercise, we're all agreed, or those two exercises, have to be done by OFWAT. And that really means that the words representation and grant are meaningless. It also, with respect, takes the sting out of the point that my Lord Justice Jackson put to me, which is that isn't this a complicated exercise? Well, it might be in some circumstances, but it's an exercise OFWAT has accepted it's got to do. And what's more, that's how it's always been. Back in the days when there were wider third-party interruption exceptions, OFWAT always had to decide whether or not the interruption was caused by X and Co with their JCB or something else. So nothing in that sense has really changed, other than the exception has been narrowed. So that doesn't answer the point. And then you're left with 30.3, which is just assertion. If such an emergency has indeed occurred, OFWAT has the discretion to grant an exception. Well, that's not plain and unambiguous, that's just proceeding by circular argument. So that's really the thrust of it, and it's not much improved when you pick through 31 and following. None of that comes to anything other than a repetition of the same essential points. It's no answer at 31 to say that the overall policy is a narrowing of exclusions. There's no doubt about that. There's no doubt that things have been very, very considerably narrowed. The question is, have they been narrowed to the point that exclusions have been completely removed and replaced with discretion, which was never the position, or they've been narrowed down to a very rare event, namely a civil emergency? 32 is a bad point. The process of making a representation would be redundant. No, it wouldn't, because we still have the burden of proving the civil emergency and we have the burden of proving fault. And one can well understand why those decisions on those adjudicative topics are entrusted to OFWAT, because it's going to want to take a consistent position on whether, for instance, a particular storm is an event that is a civil emergency. It's OFWAT that might want to draw the distinction between, yes, it's a civil emergency for Northumbrian and United Utilities in the northeast and northwest, but not for Wessex Water in the southwest. So you can see why that decision is entrusted to a sole decision maker to ensure consistency across the companies. And equally, you can see why the decision on what is or is not on the right side of the line in terms of fault mitigation, etc., is entrusted to the same decision maker.
Just looking at the words again, I know I'm obsessed with the words. and we had discussed, I thought, that the 3 million, which was due to your fault,
Yeah.
could have been more robust and so on. Actually, what the word says, where the supply interruption is not the cause of the emergency, rather than is not the fault of the company. So what is that
Absolutely.
all about?
Absolutely, and that's what I described. Perhaps I did it in too compact a fashion. I said it's like self-induced frustration, but it shows a concept of fault running through the clause, because they exempt even from the consideration of whether or not there's a civil emergency caused by the water company.
Yes, but that means the emergency.
Agreed.
But, I mean, it doesn't suggest each supply interruption has got to be assessed to see if it's the fault of the company.
And I've never suggested it does. My submission is that concept of fault on the plane of the civil emergency helps understand what on the basis of a civil emergency means, and it shows that the clause is concerned with fault. And on that basis, we say, on the basis of is the key wording, and that was the argument before the judge that he addressed at paragraph 67 and following. Not the self-induced frustration proviso at the end, but it informs how you read it. So 32 is a bad argument. The process of making a representation would not be a redundant one. The linguistic distinction at 33 between exclusions and exceptions, again, another point not made by the judge, but you have our answer to that, which is that the word exception means exception to the rule of no exclusions. And it's certainly not something that you could say is clear and unambiguous. And then you have the point of, well, this is different from the other PCs because the task is thrust upon OFWAT, as to which my answer is yes, it is. And there's perfectly sensible reasons why decisions as to whether or not there's a civil emergency and on fault are trusted to OFWAT to ensure consistency of decision making and to ensure effectively that the water companies aren't judges in their own cause on that topic. So that doesn't take matters any further. And then 35 is very, very hard to understand how all of this supports their case. They say the learned judge below was right to accept OFWAT submissions at judgment 67 to 92 that NWL's contentions, this must be contentions on plain and ordinary language, were not well founded. But only 67 to 70 deals with the ordinary language points. The balance of the judge's reasoning, to which I'll come to, are the other factors that assist in interpretation beyond plain and ordinary meanings. So we don't really, with respect, understand all of this. This is an argument that seeks to prove something that the judge didn't accept. The judge felt, and we agree, that the answer lay in fact, the wider aids to interpretation. And, you know, taking the points at 35 in their course, 35.1 is fairly striking as to how anomalous the provision that they're arguing for is compared to the others that do, we all agree, operate by reference to exclusions. (35.2), I think, when you read through it, is tantamount to admitting that the word may doesn't in fact cast any light on anything, as we have been saying all along. And 35.3 says that we're guilty of being tendentious when we point out that Ofcom had conceded that it must make an evaluative judgment. But that is what they've conceded. And I don't understand that concession has ever been withdrawn. Not least because you'd have thought, on any analysis, the relative culpability or fault of the operator is going to be relevant even on their discretionary analysis. If there's a storm and the totality of all of the interruptions are in fact caused by a catastrophic failure in planning, you'd have thought if there is the discretion for which my learned friend contends, that that's a relevant factor in analysis. The fact that they've conceded that they have to do that causative investigation.
I think I've understood it, but they just don't think it's appropriate to describe it as a concession rather than statement of the position. So in the same way as, you know, you don't have to concede that it's 2:05.
Well, the reason
It is 2:05, and it wasn't in dispute in the first place.
But the reason it's described as a concession is it appeared to be in dispute until their skeleton argument before the judge, because previously they seem to have been taking a stance where it wasn't even a relevant topic for inquiry. That's why we describe it as a concession. So we're not trying to be tendentious. So we think the real question is how to interpret this slightly Delphic provision in the light of all the objective factors. And we think by far and away the most important pointers to interpretation are the statutory scheme. And there's two facets of the statutory scheme. There's the CMA appeals policy facet, and there's the condition B12 performance facet. And we think both of those are really critical to understanding this scheme. Now, you've got my case, I think, in relation to the appeal. The structure is policy should be capable of appeal to the specialist regulator. That is a Met wand running through condition B12. Determinations, 5-year determinations under condition 9.3 are all appealable under condition 16. Condition B12.10 makes special provision to ensure that the formulae, the performance commitments that are adopted in compliance with B12.1 are themselves part and parcel of the price control which are capable of appeal. So they're appealable. In period determinations, when a significant adverse effect is identified, those are policy changes, they're capable of appeal. The only instance we can identify of any policy discretionary decision that's not capable of appeal is this one located in the performance commitments. And we say that conclusion is the strongest possible pointer that the discretion for which they're contending as baked into this performance commitment doesn't in fact exist, because it is wholly anomalous, and it results in us effectively being deprived of our rights to take a dispute on a hotly contested issue of policy to the specialist regulator. Now, the judge accepted the force of this point. He did so at paragraphs 87 to 88 of his judgment. Core Bundle 6, page 118. But he said, whilst he accepted the force of the point, it was outweighed by other factors. What were the factors that he identified? 90 and 91 show what they are. OFWAT has statutory duties which are in tension. And the absurdity of the bright lines that would be created by the distinction at 91. Now, we dealt with both of those points in our skeleton argument at 34.1 and 34.2, page 28 to 29. Let's just turn that up very briefly. With respect, the statutory duties point doesn't really move the dial at all, because this is true of any performance commitment and any judgment or incentive direction you choose to set under any performance commitment. All the rest of the performance commitments appear to be baked in stone. They're all mechanical, subject to my Lord Justice Lewis's point about potential departure from them pursuant to condition 12, 5 and 7 itself, which I'll come back to. So that point can hardly be a basis for rejecting the force of this point on the language of this contention. You could just as well say that these concerns would militate against there ever being fixed incentives, and that obviously doesn't work. Equally, the critical thing that's happened here, as we explained in 34.1, is that the decision plainly has been taken to very substantially narrow the field of argument. And that is really what we think is going on. The general approach to severe weather exclusions can't sensibly dictate the meaning of paragraph 2. And there is no evidence, as we say, that OFWAT saw NWL as best placed to bear the risks of supply interruptions caused by true qualifying emergencies. If that were the case, there wouldn't be a CE exception at all. You have to ask what its purpose is for. Why does it exist? It's got to be, its very rationale has surely got to be anchored in, well, it makes sense to make an exclusion for this truly extraordinary event with its asymmetric risks because of how that upsets the system of incentives. Then the judge's point at 91, the absurdity point, there is, in our submission, no absurdity about the adoption of bright lines. Yes, it may create some element of tough love if you're Yorkshire or South Eastern, who've had the storm but not so badly as to amount to a civil emergency. But the contract law, public law is all about those bright lines. And you couldn't conceivably design a performance commitment without those types of bright lines. The bright lines are exactly the same as the bright lines produced by other exclusions. To describe, therefore, this distinction as being absurd, we would suggest is entirely untenable. Not least since it's the type of distinction, as I've mentioned, that other regulators have adopted in other contexts. That's just not sound reasoning. You could make the same claim of any such exclusion in any of the PCs operated by any other regulator or in a contract. That's how parties manage risk. They manage it by reference to categorical decisions, and that produces bright lines. Now, OFWAT's answer to these points, again, slightly different. 40 to 42 of their skeleton argument. Their first argument is to say, well, we didn't appeal the inclusion of the civil emergencies exception. But our response to that always has been, how on earth could we have appealed it? We didn't begin to know what your policy was in relation to it. We didn't even know that there was a discretion. Objectively, there's nothing to evidence it. And we certainly didn't know that your approach could be that anything between getting nothing or only 50% or some other percentage in your discretion was going to be your approach. So that's a rank bad point. It's said that there was a full redetermination of our price cap and it left the C exemption unchanged. Well, so blinking what? If there was an appeal, which there was, but it was about other topics entirely, which it was, and it in no way involved any analysis of the C exception or the PC, how does that have any bearing on the price of fish?
What could they could only have appealed the the performance commitment anyway, couldn't they? Could they have appealed the guidance on how you calculated?
Absolutely, we say you could, because if OFWAT had been clear and said our position is that there is a discretion here, and we propose as a matter of policy to exercise this discretion in this way, we could then have appealed the inclusion of the PC incorporating a discretion that was going to be exercised.
That's not my point. That's not what you could what you were shooting at. Mine is, I'm afraid, as always, a much more basic point. Which line of which paragraph of which document says you could have appealed the paragraph of the reporting guidance to which you take exception?
You would appeal against the inclusion of the performance commitment, and you would appeal against the fact that the performance commitment set performance by reference to the reporting guidance. And that would be an appeal.
That's the appeal mechanism.
Under condition B12.10 in relation to the performance commitment and how it was calculated. So that would be perfectly permissible.
Appeal against the performance commitment and the fact that it was calculated in accordance with the guidance.
Yes, I mean,
so if you'd known that it was an exception, discretion, not an absolute exception, you'd have appealed against that.
Yep. Or we could have appealed against the fact that they said it's a discretion and we're going to exercise this discretion in this way. At which point we said, well, that's nonsense as a matter of policy. We'll appeal against that. That doesn't make any sense. That's incentivising inefficient behaviour, or whatever the grounds of appeal would be. Effectively, it would be an appeal against the drafting of the performance commitment. So that's paragraph 40, and again, not part of the judge's reasoning. Then it said at 41, and this is really pretty rich, 41 and 42 is an argument that says, well, JR's super flexible, and JR can respond to whatever the needs of the situation are, etc., etc. And the CMA has no difficulties with these issues. The problem with that argument is that they have been pretty militant in response to our rationality argument, that this is a CELCOM case, where effectively economic regulation is so complex as to be almost on the brink of non-justiciability from a substantive unreasonableness perspective. That was the argument made and accepted by the judge below, and it's also an argument they make later on in their submissions, and there's reference to CELCOM. And there's very much a cake and eating it flavour about 41 and 42. It doesn't address the gravamen of the point that we make, which is, from our perspective, there's a massive difference between having a merits appeal before a specialist regulator made up of experts who can and will grapple with policy on the merits, and attempting to challenge such a policy by way of judicial review, which, if nothing else, the case below has proven to be extremely difficult. So that's their answer here. And what's notable, once again, no attempt to defend the judge's actual reasons that I took you through at 90 and 91, save perhaps in relation to the absurdity point, because that's picked up in a different context at paragraph 38 of their submission. And I've answered that point already. The second aid to interpretation is condition B12. And it's, once you get into this argument, the full implications in terms of principle of this case really become apparent. I've shown you condition B12.7, and you've seen page 365 of the bundle. Maybe it's sensible to have that open as I make these submissions. Supplementary bundle of 365. Computer says no.
0.7365.
Yes, this is the wording of 12.7. The critical language is performance in relation to each performance commitment. A consideration of the appointee's performance in relation to each commitment. And we've seen that future performance is also adverted to, but as I've explained, that's only for the purposes effectively of smoothing, so that you don't get unnecessary swings in billing amounts. And 12.7b then requires taking account of the adjustments, the relevant price control, which the OFWAT notifies the appointee under subparagraph 12 above, in relation to each relevant performance commitment in question. In other words, it's saying you have to do the exercise for all of the relevant performance commitments. Now, our case...
I thought that we had an exchange earlier on in which you said that performance included not only performance during the storm, but more widely, and indeed the history of performance.
That would be our case if round 1B was accepted and not 1A.
I see. Thank you.
And I was careful to make that.
No.
So, the question is, what is contemplated by Part 3A, and in particular by the determinations under 12.7 in particular? And it's plain, when you read condition 12 as a whole, that the process is one in which you have to notify the intention to adopt the commitments in advance. An appeal right is provided in relation to the commitments, and thereafter you make determinations either of your own initiative or at the application of the parties. That's condition 12.2. To decide upon the performance under the performance metrics. In other words, it's simply a process to calculate the sums due under the relevant performance commitments. So the whole structure of this condition suggests a process of mechanical application of the rules of policy that have already been made to the facts as they present in each charging year thereafter.
Well, why does it say in relation to rather than under?
Why does it say in relation to?
Well, first it says shall, not shall only. And second it says shall consider the appointed performance not under each relevant performance commitment or of each performance commitment, but in relation to each. Doesn't that make it a broader
it's simply
inquiry?
saying take the appointee's performance and assess it in relation to the relevant performance commitment. Again, I come back to
each relevant. You've got to do it bit by bit, looking at it rather than
exactly so. And if you're not with me on that,
but
if you're not with
in relation to,
if you're not with me on that, my lord, that is my primary answer. My secondary answer is it supports 1B, the 1B interpretation. But none of this suggests any process of discretion, still less any discretion in which all of the duties under section 2 come into play. And were you to reach such a conclusion that 12.7 was itself a vehicle for those types of discretionary evaluations, it would mean the very certainty that is meant to be promised by the performance commitments would be undone. And yet, extraordinarily, that is OFWAT's case, and that is the case that was accepted by the judge. So their case is, as I understand it, and certainly was the case advanced below, their skeleton arguments telling me quite quiet about this, but it was the case accepted by the judge. Their case is that any of the performance commitments, even the ones that are written in terms of utterly mechanical exclusions, no argument of discretionary at all, will nevertheless trigger the section 2 duties in making the determinations, such that, if they consider it appropriate, OFWAT can depart from awarding the overperformance or underperformance dictated by the relevant performance commitments. That was the case they made below. The judge gave an example. He said, well, what if one company performs very badly in all of its metrics and the cumulative total is very large and such as to engender danger for the financial health of the company in question? Would OFWAT be able to mitigate the numbers dictated by all of the cumulative performance commitments? And Mr. Beale's answer, having taken instructions, was yes, it does. And that's why, in the judgment, the judge decided, effectively, that all of the performance commitments could, if necessary, be rewritten by clause 12.7.
I mean, it's actually 12.5 that's relevant. That's the one that says may determine the question of whether there should be a change to the revenue. And you know that under 12.7 they shall consider the performance. It doesn't necessarily mean that in determining the question they shall only consider those matters. You say yes, it is. It's implicit that it's calculation.
Yeah. You had to stand back and ask what these performance commitments are intended to do. I go back. The judge's way of putting it very nicely is they mimic the market. They mimic the network of contracts and agreed performance standards, etc.
What's your answer to the problem that I might or might not have? I don't know. But if I think that in fact it wasn't an automatic exclusion, that I'm against you on that. We've had that debate. And I've taken comfort in the fact that you could adjust the revenue and split it. You say, no, you must beat us and beat us hard. We shouldn't even have got the 50%. You say, that's just it. And you say, that. I know that you say that shows you how wrong one must be to think there's a discretion, not an exclusion. But you say, is it your case that if you're wrong on the exclusion, and it's not automatic, that they couldn't take account of a balancing of risk under 12.5 and they should have charged you the full whack.
Yes,
Gosh.
because 12.5 and 12.7 are not intended to confer any power to rewrite the performance commitments.
No, it's to change the revenue allowed under them.
Yes, it's not intended to do that either.
But
And
it's
anything
what it
else would
says.
be, I mean, take the performance commitments. They are take one that about which there's no dispute about its actual content. So it's a black and white calculation. That has to be the acme of a legitimate expectation. It has to be about the most concrete legitimate expectation. It's an expectation that is designed explicitly to produce economic incentives to shape economic behaviour. That's exactly what it's for. It's like a contractual obligation or a contractual reward. It's the exact analogue of it. It's difficult to think of a more compelling case of substantive legitimate expectation than that. The idea that simply because of the language in 12.5 and 12.7, you could rewrite those expectations for better or for worse, and effectively rewrite an forward-looking regime of pay incentives on the basis of a reference to your general duties, undoes the whole purpose of setting the incentives in the first place. The judge concluded that they were free to do so as long as the choice to do so was rational. That was his approach. And he said, obviously, it's relevant that they said that this is what they're going to do in advance, but as long as their decision to not do what they said in advance was rational, they could do so. And we say, no, that is not how this is intended to work. The statutory scheme is intended to lock in concrete and predictable performance commitments and concrete and predictable pay metrics. And the way to address the scenario that he presented is the serious adverse effects clause, which is intended to allow you to rewrite the formula in exceptional circumstances. To try to effectively circumvent conditions B14 and B15 through the language of B12.5 and 12.7 is not permissible as a matter of law. It doesn't make sense either when you take account of the regime or in account of the other provisions that do allow you to rewrite the deal. And that, with respect to my lord, is what you're contemplating. You're contemplating a situation in which the deal is clear from the terms of the provision and it's rewritten by a decision under 12.5 or 12.7 for reasons that are to be divined only from the open textured duties in section 2, which we're all agreed are intention and don't point to any particularly clear result. So I don't shrink from saying that 12.5 and 12.7 doesn't allow you to rewrite, such that if you're against me in relation to, if you're against me, with me in relation to, I still don't understand how my lord's trap for me actually works.
Well, I think you're about to have to pay back £12 million on this analysis. The performance indicator on this assumption, and it's only an assumption, no one's decided anything yet, doesn't allow you to exclude the supply interruptions due to Storm Arwen. So the starting point is that applying the calculation for the performance indicator, you should have paid 25 million quid.
But with respect to that,
and they've adjusted that by saying we're doing a revenue adjustment under 25 and 7. Now, one argument is you can't do that, and that makes it clear that you shouldn't treat it as a discretion. I'm saying, right, okay, so assume we lose that, assume I'm not persuaded by that, and it's still a performance commitment, and the performance commitment is the lot. And if you've got no discretion to reduce it by 50% when you do your revenue adjustment under 25.7, you should give them the other 12 million back.
With respect to my lord, that's neither the acceptance of my argument or Mr. Beale's argument. It's a completely different circumstance that leaves the CE exception, paragraph 2, devoid of any content whatsoever.
No, because they might have accepted it and they haven't. It's not an absolute exclusion, and if they accepted it, you'd be fine. But once they don't accept it, the question is, if they don't accept that this is applies, and if it's not an absolute exclusion, so you can no longer exist as a matter of law upon it, you have lost that case, and the Supreme Court has refused you permission to appeal. The next question is right. The performance commitment was properly calculated on the basis of including supply interruptions notwithstanding Storm Arwen. They feel sorry for you because it was a big amount in 1 year, not over 5 years, so they're giving you £12 million discount. But as I understand it, you're saying the phrase revenue adjustment under 12.5 wouldn't have allowed them to do that, and they should never have done that, as I understand your case.
I do say that.
Right, that's all right.
But my position is in relation to the CE exception, that there are two hurdles to be surmounted.
No, I've got that. It's the consequences if you're wrong.
Well, if the consequences are wrong, is that my learned friend has discretion at that stage. There's no world in which you get over the two hurdles and there's no discretion. Because otherwise paragraph 2 is left devoid of any content whatsoever. What would be the point of getting over the two thresholds? You show that there's a civil emergency. You show that the relevant event in question is not caused by our fault, but by the civil emergency. What happens then? It's either
they say, shall we give you an exception or not? And say, no, we're not going to. And then you get to the next question of, right, we're doing an adjustment exercise under 12.5. And you say they can't do that.
Probably very intense, but I don't understand how you can get over the two hurdles and not arrive in a world in which either that then entails an entitlement to have the matter excluded or a discretionary decision. It's one or the other.
Let's leave my lord to ponder on that, and you make your way forward.
Well, yeah, I'm obviously concerned about the thrust of my lord's questions, which suggests we're going to pay 12 million we haven't paid, because I can't see any.
Well, I think we're really just working through in our minds an exercise of logic based upon the various competing submissions that we're being presented with.
Yes.
So, and obviously, although they're different arguments, 1A and 1B are really concerned with the true meaning of the same exercise.
Yes. So let's look at how the judge dealt with the reliance on clause condition B12. His reasons for rejecting our case on this front are at 72 to 80. And in substantial part, they're addressed on arguments of his own making, and we've addressed them at 36. 1.
Sorry, could we just, before jumping between different pages, what are the points that you're taking out of the judgment that you want us to consider?
So if one goes to page 115.
Yes.
The first argument, which we address at 36.1 of our skeleton, page 30.
Thank you.
It's contained in paragraph 74.
74.
Yep, and it's the argument my Lord Justice Lewis put to me earlier, which is that the notion of performance is fully set by the CE exception, and on that basis, effectively, we can't point to anything other than compliance with the CE exception as constituting performance, and therefore there's nothing for the argument to bite upon. And the problem with that argument, as I explained or tried to explain this morning, is that it's circular, because it assumes, in a debate about the proper construction of the relevant provision in question, that the provision in question is discretionary. In other words, that there is no entitlement to have the exclusion operate in your favour, and because it's discretionary, therefore it assumes that you're in a situation of underperformance subject to a discretionary decision. And that's entirely circular when the rival interpretation is one that says, no, it's automatic, and if it's automatic, I'm entitled to have this excluded, and therefore we are in the terrain of underperformance. So the first vice
74, yes.
in 74 is that it's circular.
Yes.
And that is pretty much the only argument that Mr. Beale defends. He reiterates that argument at substantial length in his skeleton. The second argument the one I've adverted to, is the one with the widest policy considerations or implications. And it's the argument at 75 and 76, predicated on condition B12.5. And this is the argument that says there is effectively baked into condition B12 that general dispensing power, and that every determination under Part 3A necessarily brings with it consideration of the Section 2 duties. And that's true whether or not the relevant provision, ultimately the relevant PC, has discretion or not. And our answer to that, the answer I've given to my Lord Justice Lewis, is that wrong. It can't conceivably be intended to operate in this way to rewrite what are on any view substantive legitimate expectations. The argument proves far too much. The performance commitments must be cast in stone for the 5 years if they are to produce the effects that they are intended to have. There is nothing objectionable to making commitments that have that effect. Everything is covered by the provision of a right to appeal, and thereafter the parties work to the bargain set by either OFWAT or the CMA. And therefore, that argument cannot be right. So it's important to identify this too was an argument of the judge's devising at the hearing, which Mr. Beale then agreed with, and it hadn't figured before then. Mr. Beale's skeleton argument says nothing about this argument and its wider effects. And I should emphasise, it's this concern of principle as to why we're here, because you'll have seen paragraphs 12 and 13 of Mr. Beaver's statement. The 12 million that's an issue in this case, we don't intend to return to shareholders or to our benefit. We intend, my client intends to spend it for the benefit of those in the area. We are here because of the concerns of principle that effectively what look like cast in stone bargains are subject to being rewritten after the event by reference to the Section 2 duties. And that...
I mean, I wonder about why you should be so nervous about that. This is a case about a civil emergency.
Yes.
And I mean, you're seeking to advance your case about the consequences of that civil emergency by, as I understand it, suggesting that once a judgment such as this judge's judgment was upheld, then the whole framework unravels. That it won't just apply in relation to the 30-year storm.
Yes.
Is that what
yes,
you're...
that is the concern. And look at paragraph 78 of the judgment, page 116. Because that contains the judge's answer to my submission. This was never intended to be the case. These are cast in iron guarantees as to what's going to happen. The judge's response is, it's unlikely that OFWAT could rationally depart from that approach.
Well, why would that keep you awake at night? I mean, is there any history of renegotiating terms to disadvantage in mid-5-year period?
Not to date, no.
No, but I mean, is your submission to us that we ought to be moved by the fact that this judgment represents a springboard from which Ofwat can start renegotiating 5-year water contracts?
It does, because it says that...
Well, is that, I mean, just tell me, is that...
It is, on its face,
all right, well, if that's the submission, I've understood it.
Absolutely, that's the concern. The concern is...
Right, so that we should take a different view to the judge of the unlikely nature of that scenario. Is that it?
Absolutely.
Right, well then, that's a short point. You got it.
The point is that the regime, properly construed, is intended to produce concrete, final commitments that aren't capable of being...
But I mean, I think the point that really needs to be grappled with here is whether the recourse to the fact that everything needs to run in a predictable and sensible and consistent way is threatened by a decision in relation to an incredibly rare event. When one is moving outside the norm in order to deal with something that is not within planning contemplation. That's really the over...
I understand that, but the problem, look at paragraph 76 of the judgment. I agree with Mr. Beale that if, as the parties have agreed, Ofwat's power to make in-period determinations is derived from this part of the licence, the power is to be found in licence condition B12.5. Licence condition B12.5 contains no limit on what Ofwat may take into account when making an in-period determination. I also agree with Mr. Beale that Ofwat's duties under Section 2 are engaged whenever it makes that decision. And that applies whether or not it's a civil emergency. It applies to every single one of the performance commitments.
They can't put it up without a reason. And if we've reached the situation where we're only dealing with civil emergencies and the exclusion isn't automatic, what they're doing under B5 here and what they're talking about is bringing it down. You should have been stung for 25 million, but you're going to be stung for 12 million. If they said, gosh, this is awful, £25 million of supply interruption because of Storm Arwen, we think that's shocking, pay us 50 million. That would be a different problem.
Well, if my lord thinks that the relevant hook for the discretion that my learned friend says arises is condition B12.5, rather than, as he says, the clear and unambiguous language of the term itself, then so be it. You arrive at the same result by a completely different route. But
there's no risk to you because it's only civil emergencies and it can't go up beyond the performance condition, it can only go down.
Well, with respect, I'm just repeating myself. Yeah. I won't repeat myself. The judge's third argument is one of a supposed inconsistency in our case. We addressed that at 36.3. He says, well, we pleaded the Section 2 duties and therefore our case is inconsistent. There's a very simple answer to that, which is that we did so in the context of our alternative case. If you look at paragraph 63, which he refers to in the judgment, and then compare it with paragraph 60 that precedes it, you'll see that we do so in the context of our fairness arguments, the predicate of which is there is a discretion. And if there is a discretion, then we accept the Section 2 duties arise. So that's a bad point and not defended by Ofwat. And then the fourth point, again an argument of the judge's own devising, about condition B12.1, paragraph 80 is what this bears upon. He says B12.1 also supports his analysis, and you have my submission that all that B12.1 does is set the timing considerations as to how it is you go about setting a performance commitment, and we can't see how B12.1 has any relevance whatsoever. And again, that argument isn't defended by Ofwat. So effectively, where this boils down to is a debate about what the meaning of performance is under 12.7 and what the scope is of 12.5. Then so we have the judge's four reasons, two of which are live, two of which are not, and in relation to one of which, the 12.5 argument, we'll hear what my learned friend has to say because he doesn't address it in his skeleton. Then the third pointer is the history and context of the provision. We addressed that at paragraph 37 and following our skeleton, page 31 of the bundle. And the short point is, once you understand the origins of the reporting guidance in the report of the UK water industry group and its focus on consistency and in particular comparability, its focus on making clear, consistent and comparable metrics, then you would have to ask why it is that an exclusion would by implication, because it is by implication, generate a sort of wholly anomalous result, the importation of discretion, when such a discretion would produce the very sorts of inconsistency and non-comparability that the thrust of the report was directed against. If you wanted to compare water company performance on the topics of supply interruptions, nothing could be more calculated to make the results less comparable than including performance under a truly freak storm that occurs on 1 in 30 years. That would be the very first thing that you would strip out on the basis that it's not in fact informative about the relative performance of the companies. And that stripping out is exactly what our interpretation of the provision would do. On Mr. Beale's analysis, some discretionary portion of that goes into the metric and then forms the basis of future comparisons of performance. And that cuts right across the purpose that was the original purpose of the UK WIR. That's why we made the submission to the judge below that this would be a case of turkeys voting for Christmas, effectively of water companies and the water company representatives who largely populated the group. Not just agreeing to the narrowing of exclusions, which one understand, but the importation of a discretion that cuts across the very certainty that everyone has agreed is foundational to their business. That's why we say the context is important. Criticism is made of us pointing to the history under DG3 by my learned friend. He says it's all irrelevant. Well, DG3 was the relevant periodic review in force at the time when UK WIR was making their report. And the only point we make is the regime against which the report was formulated was one in which there was no discretion. It was all binary conclusions. It's just that the exclusions were very much more generous. And the point we make is that to move from a regime of black and white exclusions, albeit narrower than before, is one thing. It's quite another thing to move from a regime of exclusions, like excluding the data, to a regime of discretion. And you'd have thought that that would require very clear language indeed. Now, we don't really see that these points have been extensively answered by OFWAT, and our criticisms of the judge's judgment in 37 don't seem to have been responded to. I hear what my learned friend says in reply. I should say, I would accept that this is a second order consideration compared to the statutory scheme. I think the statutory scheme, both on the appeals side and condition B12, is really the most important contextual factor to assist in the interpretation of the provision. The fourth topic, paragraph D, paragraph 38 and following, page 33 of our skeleton, is the risk of inefficiency. The point here is really a short one. The judge concluded that there was no axiomatic outcome of inefficiency from OFWAT's analysis of the provision. The snowplows example. He said instead that that is a risk. There is a risk of inefficiency. And our case is that even that is enough to act as a pointer towards favouring our interpretation of the provision, because a result that excludes truly exceptional events is one that removes, if you like, altogether the snowplow issue and the risk of inefficiency that presents. And it's enough to be an interpretive factor in working out which of the two rival constructions to prefer, that there is a risk of inefficiency inherent in OFWAT's approach. And the most obvious example is, let's look at the draft determination, which they would defend as perfectly lawful. That gave a discount of nothing. That would send a signal that however strong, however bad the emergency is, you've taken the risk of it, and therefore you must cater for it and all of its downside consequences, which is going to generate the very type of risk of inefficient investment identified in the Frontier report. So that's that pointer. The last factor, E, NWL's understanding of the CWE exception. We accept that this process is one of objective interpretation. And that being so, it's somewhat odd that the judge in the judgment seems to have attached substantial weight to what he thought our subjective view was of what the clause in question meant. One can't have it both ways. If it is an objective question, as Lord Carnworth suggests it is in the Lambeth case, the judge's findings about what Mr. Beaver or NWL thought at various points in time, which we don't accept, are irrelevant. If they're irrelevant, they can't, as various indicators in the judgments that we pulled together in paragraph 39 and follows, they can't have any bearing on the question of construction.
Yes.
So,
the concept of an objective consideration of this involves not just thinking about things from the point of view of people in your client's position,
yes,
which is what you've been focusing very much upon, to do with the ability to plan a good system and use money wisely and so forth. It's also got to give some consideration to the position of your customers.
of course.
Because when we're talking about knocking about 25 million, 12 million here, 12 million there, where does it go? The outcome that you're suggesting is, of course, that if there is a civil emergency, then your customers pay for it.
Well, that's not the complete picture with respect, my lord.
Well,
the evidence is clear.
How is that not right? I mean, as I understand it,
Because all of the
because you're not being relieved of the, you're not getting relief in respect of that issue, and therefore it has to be paid for by somebody.
So the factual position is as follows: all of the customers who were affected by the storm received payments under what are called the GSS regulations.
Yes, but that doesn't help us with the. I mean, in the end, either you're entitled to charge this money to your customers, or you're not. And this is regulating what you're entitled to charge the customers.
Absolutely. So there's the micro issue of the particular customers who are affected.
No, I'm not talking about them. I'm talking about the fact that in effect the customers of your particular water company, it doesn't matter which water company it would be, but the customers of a water company will bear the responsibility, they'll bear the consequences of any civil emergency.
Ultimately,
it's not.
yes.
It's not the usual thing where we're looking across the court and saying, is it going to be your team or their team that bears the result of this? It's frankly that the householders will bear the consequences, undiluted, of the civil emergency.
Those affected, the people who actually end up bearing the risk, are the people who suffer an interruption of service in consequence of the civil emergency. That's the people who bear the risk. Because they're excluded, that doesn't affect the charging metric. The charging metric will affect all customers, because obviously it affects everyone in the supply area, and it will affect everyone's bills. And that's why it is relevant that the customers who are affected, it's not correct to say they bear the totality of the risk, because they receive the payments, and it's many millions of pounds. It's in Mr.
The customer base as a whole bears the risk, rather than the company. Is that it?
It's that effectively the company's revenue is not adjusted by reference to the fact that the service it ordinarily provides couldn't be provided in a civil emergency.
You talk about it as the customer's revenue, but we've also got to consider, if we take an objective view about this, the householder's bill.
Yes.
I mean, the householder's bill and the company's revenue are two sides of the same coin.
Absolutely.
I appreciate it's a coin that's probably got more than two sides, but nevertheless, those are the big picture situations. And so I just give you the opportunity to consider the fact that when you're talking about things to do with the documents we've been looking at and the objectives that are there is, I mean, OFWAT is here in a regulatory capacity, but in a sense there is an absent third party here.
Yes. And
who are your customers.
I should say, Consumer Council for Water put in representations. They supported OFWAT's position. I don't hide from any of that.
But I mean, you would accept that an objective view of this does not simply mean what looks reasonable from the point of view of the.
Of course not. It's what an informed observer of the process would say was meant by the words on the page. An informed observer with a full understanding of the complexities of the water regulatory system. Yes. That's the relevant test. It's a well-informed, officious bystander.
Yes. So if we've got a civil emergency, who should bear the risk? Should it be?
Yeah.
Should it be all on the water company?
Yeah.
Should it be all on the customer?
Yeah.
Or should there be some intermediate mechanism, such as that provided here, in order to sort it out?
Well, that will be part of the, if you like, consideration that would be adopted by someone.
But that's the even bigger picture than what I think we've been concerned with.
And for that reason, that's the reason why we've also said an informed bystander would know what happens in other regulated contexts. And here the peculiarity is, all of the problems are caused by Northern Power Grid's power system failing. The problems for us are entirely consequential of that. And Northern Power Grid get a complete free pass.
The customers paid for a service and they didn't get it, and the question is, should they get some money back?
Well, no, that with respect is not the correct analysis, because the customers who didn't get the service, who experienced supply interruptions, received compensation payments under the GSS.
That was my point, was a different one.
Yes, it is.
But the customer base as a whole are paying bills to provide for the service and the rate of return for you. And when the service isn't operational...
Well, that goes back to the snow price one, doesn't it, my lord? Because if the customer is going to have to pay for a service that caters for perfect service, even for 1 in 30-year storms or truly rare events, the service is going to cost a very great deal more. And the consequence may be, okay, you have total resilience in Storm Arwen, but it's going to cost you £5 a year more every year to secure that resilience for the 5,000 or 800 odd properties that might experience a disconnect when one of these rare events occurs. And that's the economic inefficiency. So, I better wrap up on ground 1A. Ground 1B,
thank you,
we have treated very briefly in our skeleton, because you'll immediately understand how it's a narrow iteration of ground 1A. It turns upon the language of condition 12.7, and it says, well, if there is a discretion, it's not some utterly open-ended discretion in which you can take into account of all of your regulatory functions. It's one much more laser-focused on the question of performance in relation to the particular supply metric in play.
So we've got 42 to 44
exactly.
on that.
And it's basically a kind of analogy to Padfield. The purpose of all of this is supplied by condition B12, B12.7 in particular. The purpose here is to incentivise performance by reference to these topics. And anything that goes outside the topic of performance for supply interruption, etc., is off topic and therefore not a permissible basis on which to make an adjustment. So that's the alternative case. Ground 2, I'm going to have to take very much at pace. The starting point is Mr. Justice Fordham's judgment in the ZLL case, recognising a duty of prescription, that is, a duty where the context in question demands it, that's the critical rider, to spell out in advance how you're going to exercise a discretion by adopting a policy. The judge accepted the analysis in principle in ZLL, but decided on the facts of this case that no duty of prescription arose. So no dispute that there was, in principle, a potential for such a duty to arise, but given the contextual factors, no such duty.
I don't think that all members of this court would accept that there is, as you say, a well-recognised duty, even if the judge thought there was.
That was rather what I apprehended the term of debate to be, because
well,
my learned friend, Mr. Beale, pretty much makes that argument. His skeleton's not the clearest as it can be. He basically says, he comes very close to saying Mr. Justice Fordham is wrong and there is no such duty of prescription. There is no respondent's notice. That is a point that would require a respondent's notice. Again, I'm happy to deal with it.
Well, where do you say, just so we do this justice, you've had fair warning from the grant of permission to appeal of one view of ground 2.
I'm happy to argue it.
No, quite. But what I mean is that this is a point that we need to consider, whatever its merits. Where in starting at judgment paragraph 93, do you say that the judge, as it were, accepts what Mr. Justice Fordham said, or in a sense is he simply relating?
Well, what he does in 93 is he sets out, without any criticism or suggestion that it's not correct or not the law, quite difficult, I suppose, socially for a judge sitting in Leeds to do, 93 sets out the test, then reiterates Lumber, and he also looks at B, and then he goes back to what Mr. Justice Fordham says at 45.1, which is context specific, and then he says simply, the present case is not a case where the duty of prescription applies.
Yes.
He doesn't suggest that there is no duty of prescription, which he surely would have to if he thought the decision was wrong.
Well, we're not concerned whether there's such a thing as a duty of prescription, because there can be. It's a question of whether it arises in this case.
I think Lord Justice Lewis would not agree with that.
No, but I mean,
I haven't come to a view. I'm just saying you mustn't assume.
Mustn't assume. Well, there you go.
there is such a thing as a duty of prescription that has been found to arise in certain circumstances. The question is whether this is such a case, namely whether it's appropriate to say that that OFWAT was in default because it didn't have a policy for 30-year storms. That really is the gist of it, isn't it?
Let me
and how does that fit with where...
Try to address the fullness of the
Yeah.
argument, both on the plane of principle and on whether it arises in the present context. I readily accept that the cases cited by Mr. Justice Fordham, B and Lumber, are cases that deal with a different scenario. They deal with situations where there were extant policies. Lumber, like very many of the cases to do with the law in relation to the duty to adhere to policy once it's been adopted, is a Hardial sin case. Many of the cases on the topic of policy, Nadaraja, Kambadzi, Lumber, they're all Hardial sin cases at the end of the day. And they're all cases where there were operative policies, and the vice in Lumber is obviously that the policy hasn't been published. But you have to ask...
Well, Lumber was worse, wasn't it? Because there was a published policy, and the unpublished policy contradicted the published policy.
You're quite right, my lady.
So it's quite a...
It's actively misleading in those
Yeah, it's quite a unique
Yeah.
set of circumstances, one would hope.
But when you look...
ZL, did ZL find that there was an enforceable common law duty, which was the remedy of mandatory order,
No.
or did they find that the decision in that case must have been unlawful because they could not be in exercise discretion without a policy, or did it simply not arise to its overturn?
Mr. Justice Fordham's conclusion in that case was that there was no scope for the common law duty because of the detailed provisions of the statutory regime and statutory guidance, and so it was a context in which effectively statutes applied all, and it couldn't be rewritten by the common law
Sorry,
duty.
because I'm not as familiar as you are with this. Does that mean that the comment was overturned? That the observations are overturned?
Yes, I think it does mean that.
Right.
And I also accept the comments of Lord Justice Sedley in the case of B, which Mr. Justice Fordham cites, are overturned. Because B was a case all about an issue of law as to whether or not the DWP had a power under Section 71 of the Social Security Administration Act to demand a repayment of a benefit mistakenly overpaid. It all turned on what not disclosing facts known to you turned upon in a case involving someone with limited mental capacity and whether or not that could satisfy the test. What Lord Justice Sedley then said about the need to adopt a policy, having found the power to exist, is therefore overturned. And necessarily it was overturned because the case was an appeal on a point of law about the proper construction of the relevant provision from the upper tribunal.
So is there any case, you say it's well established, is there any case where either a mandatory injunction or order has been granted to force the giving of judgment, or any case where they said this exercise of discretion must be unlawful, and presumably all exercise of discretion to the power are unlawful because there's no policy in existence? There's no such case.
There's no case that we can identify. No. But we say, when you look at the reasons of Lord Dyson in Lumber and the reasons given by Lord Justice Sedley in B, they are powerful reasons as to why context may dictate that in certain areas you need to adopt a policy to explain how you're going to exercise the power. And the reasons are consistency of approach, the ability to make representations that are targeted at and directed at the policy then in force, and we would say, and this is from first principles, readily recognised, when you're dealing with a system of incentives, the need to have a policy in relation to a discretion is the function of parties needing, in fairness, to be told what the rules will be in advance before they take the conduct that is intended to be shaped by the regime in question. So we're back to Jeremy Bentham and dog law. Jeremy Bentham would undoubtedly be a fan, if there were to be a discretion of this kind, of a duty of prescription, because it would tell you more detail in advance about how the decision in question is going to be taken.
All of that is well recognised. There are books on it, and principles of good submission and so on. The next question is, if there is no such policy, but you say the conduct is one that dictates it, what does that mean? Does that mean that every decision, such as the one here, is automatically unlawful? What's the end result?
The end result, the logical consequence, as we explained in our skeleton argument, is that the policy should have been adopted at the same time.
But it hasn't been, so what happens next?
What happens next is either no operation of the policy other than the binary operation we envisage is possible, because that's the only fair result, or alternatively, you get to a section 1B scenario, because what we would accept is that the terms or the face of the condition read with the policy may give some indication that considerations of performance are relevant, and that's why we put in submissions directed to our actual performance.
Can you go through that more slowly with me? Because there is no policy here, and there's something you call a duty of prescription which required one, that means that the legal consequences is that we must interpret under ground 1A the...
That's right. Because
right, okay. So that's your first submission. The absence of a policy means you go back then to, if you win on ground 2, the absence of a policy on ground, and win on ground 2, means you must then go back and reinterpret ground 1A.
Absolutely. And that's because any other policy is going to be adopted after the event, i.e. after irrevocable investment decisions, etc. are taken. The whole purpose of the requirement for a policy here is to shape the conduct, to provide the incentives.
Yeah, I'm worried about the remedies now. I understand the rhetoric of the remedies, and you say the remedy is that even if we had worked through this and found on ground 1A that it did not provide for an automatic exclusion, it was a discretion. As I understand it, you say because of the duty of prescription, which you say applies here, and because of the absence of a policy, the requirement is we must revisit ground 1 and interpret the exclusion exception differently from how we would have interpreted it had there been a policy.
That is correct,
yes.
Because the consequence of any other approach is unfairness. And the unfairness is the making of the rules after the relevant conduct that the rules are designed to incentivize.
And then your alternative was, and it may come to the same thing, you've got to exercise your discretion in the way that is most beneficial to the person, because there's no policy saying how you're going to exercise it on a more limited basis. Is that it?
No,
is that the remedy?
Exercise it in the fashion consistent with the indicators of the considerations that are relevant, and the only indicator of the considerations that are relevant are condition B12.7 and the consideration of performance.
Yeah, but assuming that you've lost on that under ground 1, we're going through it sequentially, and we get to ground 2, and the only thing that we say that is legally wrong here is that there was an obligation to produce a policy. No such policy was produced. A decision was taken in the absence of such policy. What remedy do I give? Answer 1, reinterpret the paragraph and revisit ground 1A. On ground B, what do you say the consequence of the absence of a policy where one was legally required means in terms of remedies under ground 1B?
In relation to ground 1B is that there can be a reassessment confined to the questions of performance under the relevant supply interruption metric.
Not because it is legally required, because we decided that against you, but because otherwise...
Because it's the only criterion that looking at the matter in the round is fairly set out in advance, and it's set out by the licence condition itself.
So your case is that in this case Ofwat was under a duty to formulate and publish a policy as to what it was going to do in relation to civil contingencies.
Absolutely.
Now, and what's the? I mean,
that doesn't.
Can you show us any case in which such a conclusion has been reached that is at all reasonably relevant to these circumstances?
Well,
It wasn't found. I've been looking at ZLL. That really didn't arise at all on the facts of ZLL, which is a big question, street homelessness, and it didn't arise.
One of the difficulties, I totally accept the forensic point my lord makes that there's no case comparable to this, but I would equally say very difficult to think of any case where effectively the regulator is determining how much you're going to get paid.
Yes, but it's very difficult to think about what sort of policy you could possibly make. I mean, civil emergencies include, God help us, a nuclear attack.
Well,
I mean, what is OFWAT meant to do? To produce a policy that covers every single catastrophic
that's a straw
event?
Man. That's a straw man. That's my learned friend's case, which is that it's impossible to produce a policy. Look at the list of
face up to what the consequences of your submission are. I mean, they would have to create a policy for every form of civil emergency, would they not? Otherwise, every time there was one of those civil emergencies, they'd fall foul of your ground too.
With respect, my lord, that doesn't follow.
Why not?
Why not? Because there are certain civil emergencies that you can triage and say that is obviously something that is a relevant and likely risk for the water industry. Weather-related events, whether it's flooding, extreme drought, extreme cold, extreme wind, those are well-known topics.
So what policies do they have to have?
What policies do they have to have?
In relation to civil emergencies, as you're cutting down on civil emergencies as a whole?
First of all, if you go back to the final determination and you look at the content of the final determination, that in itself constitutes a general policy as to how they're going to address these issues. A general risk-sharing attitude that is expressed in advance. Now it's 50-50. Even if that were the general approach, which it seems to be, and it's not identified as being focused upon weather events in particular, that in itself is a statement of policy that should be set out. Then, are there any exceptions to that? Is that a policy that only applies to the most predictable things like weather, because lots of the discussion in the regulatory context is to do with weather events? Does it apply to, for instance, poisoning of a water supply by a terrorist? Yes or no? You can set out the basic principles as to how this issue is going to be approached without setting out an exacting approach for every one of the 600 odd risks on the Civil Contingency Secretariat's list of civil emergency risks.
Let's suppose we're against you in relation to this, and your clients felt strongly enough about it. Then presumably, I mean, at the moment, are we in the last year of a cycle?
Yes.
They can take it to the table, can't they? In relation to that,
undoubtedly,
if they think there ought to be
at the next
policy.
TR24, it can be taken to the table.
Yes.
Undoubtedly, the risk allocation that's now evident can be taken to the table. That's not much comfort in relation to events that have passed, in relation to investment decisions that were taken in the past, and that's the peculiar context of this case. Most policies in the field of administrative law are directed to what we call the dual needs. In other words, consistency of decision making and the ability to make informed representations. Consistency is surely important here because someone else presenting with a civil emergency is going to want to have the same approach applied to them. The ability to make representations, well, it's no comfort to us that the decision's been taken by a senior decision maker when the actual policy has only been landed at the very end.
It's not just a question of there being the opportunity to do better in future if you say this is what ought to be done to make these things better or indeed lawful. This is something that the Water Industries Working Group made a pass over this whole area, and what was that, 2015, 16, 17?
2017, 18.
17, 18. And nobody seems to have pointed out that you need to have a policy about that.
Well, to an extent, the absence of a policy is, I would suggest, rather indicative of the fact that no one thought there was a discretion of this type of width in the first place. And I go back to the point. You say to me, where are the cases where the duty of prescription has been applied? Where is the case where a power, a discretion of this kind has been identified after the event to determine after the event how much someone providing a service is going to get paid. If this were a contract, it would be the acme of an unfair contractual term to put it in the party's gift to decide how much to get paid after the event. That's a very unusual scenario. I can't think of any case, I've been doing regulatory JR a long time, I can't think of any case where you decide as a matter of policy after the event how much someone's going to get paid. That's a strange context for such a discretion, and it's that strange context that leads us to say, if that's the rules of the game, then exceptionally, on the facts of this case, there's a duty to spell out what you intend to pay, at least to a level that it's comprehensible in advance. I sense I've trespassed on my
Not at all,
patience.
hardly at all, and you've been engaged in argument. Thank you very much indeed, Mr. Yes, Mr. B.
My lords, my lady, OFWAT submissions will make some introductory comments, which will give an overview of our case and a brief response to my learned friend's submissions. I then propose to look at the evolution of the performance commitments and the text of the CE exception, and then I'll deal with the grounds of appeal in turn. My learned friend helpfully has covered a lot of ground this morning and this afternoon, so I can be briefer on certain parts. He took you to the terms of the Water Industry Act 1991, and your lordships, your ladyship are very familiar with the four principal matters that have to be considered. It's matters such as the consumer objective, the resilience objective, financing of water companies, and so on. But the principal power that has been exercised here by my client OFWAT in the contested decision was a determination of the adjustment that was needed to the allowed revenue for Northumbrian Water under a price control procedure, and that was the condition B 12.5 power. That power that was exercised in the contested decision. The procedure set out under paragraph 12 of condition B allows for adjustments to the allowed revenue to cater either for overperformance or for underperformance. So it can go both ways in principle. It just so happens that in this case, there has been substantial underperformance by the water company. Condition B 12.7 identifies the factors that will be taken into account when making that assessment, but as my Lord Justice Lewis made clear in argument with my learned friend, they are not an exhaustive set of criteria to be applied. And in any event, our submission is that OFWAT as a regulator is bound by statute to give effect to its statutory duties, which a regulator cannot. And we say that applies equally when they are discharging functions under a licence condition, which albeit is part and parcel of its regulatory duties, is nonetheless legally subservient to powers granted by statute. So one has the section 11, section 12 conditions which can form the basis for the licence. The licence therefore is a product of the exercise of statutory duties. It doesn't have the imprimatur of the Parliament behind it as such. Now, as part of that procedure, what OFWAT does is it determines the nature and extent of the compliance by a water company with the performance criteria that are applicable to it. And so for any in-period determination of an adjustment, it will look at to what extent has there been compliance, either over-compliance, they've done better than they should have done with the performance criteria, or under-compliance in the sense that their performance criteria have not turned out as they should have done. And the consequence of that will be that the revenue that is made available to the water company can be adjusted. And this is just a straightforward feature with respect to the price control regime. With effect from PR14, what OFWAT introduced was a change in allowed revenue to reflect more accurately the performance of water companies and the imposition of stretching targets so that the consumer would benefit from improved service. Now, for water supply interruptions, the general position, as we've seen, is that there are no exclusions. That's in contrast to other performance commitments which may or may not have exclusions. And what that means is that for this particular performance commitment, there is nothing to come out of the calculus once one has worked out that there is, as here, underperformance.
What's an example of something that which does have exceptions?
If my lord would be kind enough, please, to turn in the supplemental bundle to tab 10. Page 173. One sees reporting guidance for mains repairs per 1,000 kilometres. This is to deal with the performance on mains bursts, and one sees key principles are then set out. There are several assumptions behind the compilation of the guidance. There's a requirement to have a methodology and a reporting process, and then the last bullet point on that page, exclusions are to be kept to a minimum and shall be consistent with the reasonable expectations of an affected customer. So that's repeating the mantra.
So where are you on 174, did you say?
That's 173.
Oh, sorry.
And then 174 gives effect to that principle of the minimal approach to exclusions. And it says the default position is the water company manages the risk of mains burst and there are no exclusions. The cause of the main burst is not relevant to the calculation, so thus far it's keeping pace with the supply interruption exclusion position, with the following exceptions and points of clarification. And the second bullet of those is that all third-party damage should be excluded where costs are potentially, rather than actually, recovered from a third party. And one sees the first bullet point is any work that's not undertaken on the main itself. So if it's on a piece of the asset that isn't related to the main, then it's not dealt with under this performance criterion. We then see in the measure definition my land friend wants me to make a forensic point for him and say it's an exception, not an exclusion.
It's an exception from the exclusion. Sorry, it's the same thing.
Yes.
Well,
Right. So we see in the little chart at the middle of the page we've got a repair lozenge.
Exactly, and that's included, and that's in contradistinction to the
Yes, we can remember
absence of the flow process diagram having one for
All
exclusion.
right. Thank you. Thank you.
That's an example. There's another one on outage. That's at page 181. One sees the similar process where exclusions in this instance for water quality and other matters are permitted and described in 5.6. That's then built into the flow process chart, and the actual terms of the exclusion are at page 185. In particular, that is an example at 185 of extreme weather. See second paragraph from the bottom. Extreme weather can result in raw water quality events as described above, i.e. Inappropriate access of poor quality water into the water supply mains, and that then extreme weather can therefore give rise to an exclusion on the facts of that particular performance commitment.
And can I just check, being obsessive, that these two documents have the same status as the document that we've been looking at for water supply interruptions, i.e. their guidance given by OFWAT as to the method of interpreting or applying the performance commitment?
So the answer to that is yes. Formally, and I don't wish to be pedantic, but I probably ought to be, the document at tab 11 is a recommended KPMG Jacobs draft. But my understanding is even though that this is in track change format, it then represents the text that was formally approved by OFWAT.
Why haven't we got the text?
I don't know the answer.
But you're telling me there is text of the same status as the one that we're looking at, and that tab 10 is of the same status, and therefore you're inviting us to say that when they mean exceptions, they say it, and when they mean opportunity to apply for exceptions, they say it. Is that it?
So an exclusion operates to mean that you do not put the data into the calculus in the first place. And we see that most clearly in the process flow charts. My learned friend said UK water industry report is the Fonte Origo of the text, which is true. That didn't contain the process flow charts. What OFWAT then introduced to the guidance was the way in which you would plug in certain exclusions from the reporting data. Now the CE exception doesn't work like that. The CE exception works on the basis of all of the data goes in and gets reported, and there's no step in the process flow chart to suggest that data is excluded at any stage. But then, on its face, it invites a representation to be made that that policy of not having any exclusions for water supply interruptions should somehow be dealt with differently.
And what do they do? Are they applying for an exception to say we want to take the data out? Or are they really, I wonder, applying for an exemption in the sense that the consequences of having put the data in should be mitigated?
Those are two paths up the same mountain in my submission, my lord.
Right. What was my first pass? I've forgotten it.
The first path would be taking the data out retrospectively from the calculation that's already been performed.
All right. And my second path was...
Your second path
Oh, yes.
was to deal with the financial consequences.
mitigating the financial consequences of having put it in.
Exactly.
And which is it then?
Well, it could be either,
Oh.
because it depends on the representation that is made by the water company as to what consequences are, they say, of the civil emergency. And that's
All the figures have got to be produced. Nobody's doubting that they've got to be actually be reported.
Yes.
But whether you then go on and feed them in,
Well,
or not feed them in and then, as it were, take them out afterwards, or don't feed them in at all, is the two paths.
Can I give you a very prosaic
Yeah.
answer, which is that there is bespoke software that's been developed for the water companies where all of this gets fed into a computer program, not dissimilar from a pretty complicated Excel spreadsheet, which gives you the line figures for each of these elements. That software has macro stroke algorithms built in so that certain calculations are produced. But the data will be there. That's in contradistinction to an exclusion, where if an exclusion is, as shown on the process chart, that exclusion will mean that the data doesn't get put into the final line items in the spreadsheet as it comes out and gets given to my client to review and monitor. So there is a system, there's a process system, whereby the reporting gets given through to OFWAT, and for true exclusions, the data never gets given in the first place.
But here, the data would always be given to OFWAT, and the question is whether they go up and down the mountain on one of these paths of taking it out again, or saying, well, we know that this would lead to £50 million, but with those kinds of regulators, it's 25 million done.
What I'm not excluding, forgive the pun, is the possibility of a water company filing a revised spreadsheet with the data removed.
I see, so it could come out that way.
But why would you bother going through that when actually what you're caring about is the pounds and pence on the bottom line of your allowed?
The financial consequences arising from that data.
Yes. So, and we are not prescriptive. Obviously, that's criticism in ground two. We're not prescriptive about how one makes a representation to us.
But could I just be clear about, is there any situation in which the water company would not report the raw data?
Well, only if they're failing in their duties.
Yeah, well, exactly. But in other words, legitimately would say, well, we don't need to send that to you because this exception, this exclusion applies. I mean, I'd understood it to be that everything has got to be on the table, and then there's a discussion about, in certain circumstances, what is made of it.
No, I think some of the exclusions operate so that the data doesn't go in there in the first place.
But I'm not talking about going in. It's a question of whether it's sent to you. I mean,
I don't think it would be. I think that the operation of the spreadsheet would mean that you only put in what I would call the net figure. So once you've stripped out the bits that don't have to be reported.
And then how does OFWAT know what's been stripped out?
Well, I think that would be part of the monitoring system, that they would just have to audit the report and see on what basis that the
All right. Well, I had a cherished certainty, which I'm now having to set aside. Which I thought that the whole basis of the system was that the water companies reported everything, and then there was a discussion about around the edges sometimes about what it meant. I'm getting a tableau of sort of heads moving in different ways behind you, so I'm not really quite sure where we've got to.
I will double check overnight, my lord. But
yes, thank you.
If one just looks at page 181, the most recent reporting process I just described, then the flow chart, as I had understood it, but it's entirely possible that the exclusion takes effect through a cell in the spreadsheet, so that I'm both right and wrong.
Well,
the underlying data's there.
No, I mean that's what I thought. I thought that all data had to be fed in at some point, even if it was then to be neutralised, taken out, or whatever you do with it.
Would you give me a moment, just so that I might perhaps shoot this box? So my instructions are that there are certain exclusions, and the two I've taken the court to are situations in which the data doesn't go into the spreadsheet at all.
So it doesn't arrive with you.
Sorry? But the trouble is my learned friend's saying there are others, and my understanding is that some of them may require the data to be reported, and then it's not taken into account in the calculation.
Okay, so in other words, what I had been repeating a couple of times earlier on, which is that all the data arrives, it's then treated in a certain way, that's an oversimplification.
It's not accurate for every response.
So the fault is mine, Madam. When I answered those questions, I thought you were directing your question to this particular performance commitment, which is obviously the case. All the data is reported.
Well,
as I understand
in your case,
that's right.
you have to report the data in order that you know what you're discussing.
But as I understand the position, there is a spread. There are some where you can self-administer, you don't report the data. There's others where you exclude but report the data. So,
thank you.
So what we say is that the CE exception permits water companies, if they choose, to make representations to OFWAT for the grant of an exception to the general policy of no exclusions. Now, true it is, the ability to make that representation is conditioned on there having been a civil emergency, and also that the supply interruption that causes the civil emergency is not a supply interruption that is laid at the door of the water company. So if, for example, a water company has failed to maintain adequately the wall of a reservoir, which is above a town, the wall fails, the water floods the town, that may well, depending on the facts of the case, give rise to a civil emergency. That would be an example of the civil emergency having been derived from a supply interruption caused by the water company, for example. Or if, I don't know, there was a wholesale failure of the water supply network in a large city or town, one can see that there might give rise to a civil emergency, but it would be the water company's responsibility for that civil emergency. What we're dealing with here is not that type of civil emergency. It's a civil emergency which has caused a supply interruption. And once that parameter is ticked, we say, with respect, there is no scope for a fault, no fault analysis. Because the fault simply does not come into what has given rise to the supply interruption. That's a straightforward, well, not that straightforward in certain circumstances, but where, as here, there's a large storm which has taken out the generators that are pumping the water. Storm Arwen has caused that supply interruption.
But I thought, although it was never easy for me to get to the bottom of this, I thought that we'd got to the stage of Mr. Delamere, because I kept asking, well, why are you giving up £3 million anyway? That he is saying that the phrase on the basis of a civil emergency means that you had to go through each property and number of hours to see whether that was on the basis of something that could have been prevented by them, notwithstanding the civil emergency, or the more broad thing was all these lost their supply because the thing was blown out by Storm Arwen.
On his case, if I may respectfully say so, he's been too timid.
Oh.
Because he should be saying, it's not, I'm sure it's not an allegation that's frequently.
It's very rare, yes, we're making a note.
Say that
Mr. Delamere understated his case. So he shouldn't even have given you the £3 million?
No.
Right.
Not on his case.
Because
it's not a fault, no fault situation.
An ability to prevent the thing occurring is not the same as it occurring because of the fault. Yeah.
Correct. It would be a failure to mitigate.
Failure to mitigate is not the same as caused by it.
Not the same as causing it.
Yeah.
And if ultimately the storm has taken out the pumping station, the fact that you haven't been terribly diligent in getting the pumping station back up and running would be you failed to take adequate steps to mitigate an occurrence that has occurred because of a causative factor that is external to the water company.
Yeah.
And we would recognise that that is a third-party cause of the supply interruption. But that's why when the policy says there are no exclusions and it doesn't matter whose fault it is, whether it's a third party or anyone else, that is the parameter by which water companies are now judged.
One final question, I promise you, on what you've just said. There are exclusions, which means sometimes the data doesn't arrive, and there are exclusions where the data arrives but something else happens. When I look at page 163 and it's headed exclusions, the default position is that the water company manages the risk of supply interruptions and there are no exclusions, full stop. No exclusions of what from where?
Well, this is, I'm afraid my answer is going to be the same, which is ultimately it all boils down to the same thing. Because if all of the data is in, and the analytical task that one is conducting is what is the consequence of that data, the answer is there's been widespread underperformance against the supply interruption criteria, not for those 2 days in November or 3 days in November in question, across the entire year. And that is the task that is being conducted. And what page 163 tells you is it doesn't matter whose fault it is, it doesn't matter whether they're planned or unplanned, it doesn't matter what the cause of the interruption is, because that's not relevant to the calculation of the reported figure. So for whatever reason, you end up with a supply interruption figure after a year that is not compliant with what is expected of you, that's an underperformance.
But what does exclusions mean in the last word of the first sentence? Exclusions of what? From what?
It means a variety of things. Primarily, in this context, it means an exclusion which would otherwise take the data out of the reporting process, or an exclusion would somehow see the particular factor that is identified as giving rise to an exclusion, meaning that the calculation is lower than it otherwise would be.
So say that again. Exclusion would take the data
Out
of the normal report.
strips the data out, or it expressly says in terms, this is not going to be taken into account in the calculation of the final performance figure. And that's what exclusions do. They reduce, they adjust in the course of the calculation the figure you get from a performance determination. Have you met the performance standard? Have you exceeded it? Have you gone below it? That is what this is intended to do. And I respectfully agree with my learned friend Mr. Delamer when he says it's intended to be a predominantly mechanistic process. It is.
Then you get to exception, you see, because that's an exception from the exclusion, and now the exclusion means different things.
Well,
exempted from inclusion in the calculation or exempted from having to give you the data. It can't mean the former, they've got to give you the data. So it's got to be exempted from inclusion in the calculation of the final figure.
Yes, in this case. But one sees similar wording used elsewhere. But in any event, what it's being designed to determine is, are we going to make an adjustment for a given reason to the performance determination that is part and parcel of this process. So this test, this reporting guidance is there in order to identify on a year-on-year basis whether or not a water company has met its performance commitments, whether it's exceeded them, or whether it's fallen below them. And the outcome is going to have an impact on the revenue that is permitted to them under the price control. And that's the entire structure of the price control regime. OFWAT incentivised water companies to provide stretching commitments so that if they met them and then exceeded them, they would get the benefit in terms of cold hard cash in their collective pockets. But if they fell short of them, the consumer would benefit because the bills would be lower, because the allowed revenue would be lower. It's true, it's incentivising better performance by water companies because they are regional monopolists, where otherwise there would be a risk of market failure because there is a regional monopoly and there's no market mechanism in place, and service would unduly suffer as a result of that position.
You were starting to say something in agreement with Mr. Delamer about predominantly mechanistic process. Do you want to develop what you meant by that?
What I mean by that is that when one's looking at have you met the targets for a given common performance criterion or a bespoke one, the formula that are used are designed to enable a water company to know whether or not it's met the performance commitment. And so you feed the data into the, I've called it the spreadsheet, it's a bit more grandiose than that, but you feed the data into the system and it produces the answer. Now what the Civil Contingencies Act exception does not do is change that process. And it's evidently not intended to change that process.
There will always have been a failure to meet the performance commitments in relation to water supply, even if there's been an interruption. So the exception must be aiming at something else other than defining whether there's been a breach of the performance commitment. Is that what you're saying?
So the exception must necessarily be to the circumstance in which you're going to end up with a given result, which is in this case, the water company failed to meet the common performance commitment and it failed to meet one of its two bespoke commitments that it itself had put forward with a view to no doubt exceeding and getting money from. Now that gamble failed, and the consequence of that is, on any view, too many customers in the supply area suffered from supply interruption, which Ofwat treats as one of the most serious forms of failure by a water company to meet its obligations, because it has a very substantial impact, particularly on those people who aren't able to get out and get an alternative source of water, for example, from a shop if they're in rural areas or they're disabled or otherwise unable routinely to get access to fresh water somewhere else. So Ofwat views this particularly seriously. That's my, I'll turn the light off back in the jury box now, that's my jury speech made. What I would say is that the exception, therefore, is recognising that if you are not to be have attributed to you the consequences of the calculation which would otherwise flow, you're going to have to tell us why we shouldn't do that. But it's entirely within the water company's gift as to the nature and extent of the representation they make, if any, to Ofwat. And the request is for an exception from the normal method of calculation to be put in place by Ofwat. Now, whether one views that as taking the data out or simply looking at the consequences of the shortfall in performance and changing the metric by which the performance is adjudicated upon, it doesn't actually matter ultimately, because substantively what Ofwat is doing is looking at the representations and working out effectively whether or not the company should be relieved of a burden that it would otherwise bear under the normal operation of the price control mechanism. So this is a relieving provision. I'm perfectly prepared to accept that it operates effectively on a concessionary basis. And it's none the worse for that, because it's recognising that it is open to Ofwat to consider the fact of a civil emergency and to consider the consequences of that civil emergency and to determine to what extent, if at all, as a concessionary safety valve, the full consequences of the water supply interruption should not otherwise be visited on the water company. So it is a concessionary measure, but it's a concessionary measure against the default policy position expressly stated on its face here, that you are liable for water supply interruptions and it doesn't matter whose fault it is. So we say that is the proper approach to the CE exception. The CE exception itself, of course, says nothing about what Ofwat must or must not do. It doesn't even say that Ofwat must consider the representations. So in order to consider the representations, well, Ofwat recognises that if it didn't consider the representations, it would be likely to be brought before the administrative court with alacrity.
Well, it must implicitly be. I mean, what's the point of saying you can speak, but I don't have to hear?
I agree. With greatest respect, I absolutely agree. But the point is, it's not written there. And so one necessarily
That's against you, I think. Be careful.
We have to read into this particular provision.
As a matter of necessary implication.
Exactly. That Ofwat will consider the representations and work out what to do. But in doing that, it will necessarily be guided by its Section 2 duties, which guides everything it does. And it follows also, we say, from the in-period determination of what the adjustment should be, that it's implicit in that process that if representations have been made for this purpose, and otherwise the adjustment would be at this level, but with a representation it might be considered to be appropriate to have a lower level, that feeds into then the parallel process of working out what the relevant allowed revenue should be by way of adjustment under condition 12, B12.5.
was my next question. So OFWAT are adjusting the revenue, notwithstanding the performance commitment being breached. They're not adjusting the performance commitment.
They're not adjusting the performance commitment. What they are adjusting is the allowed revenue, which would otherwise assume that there has been a level of failure on the supply interruption criterion, which is at level X. What the power to make a representation allows the water company to do is to seek to persuade OFWAT that the adjustment should be X minus Y. And that Y is the invocation of the discretion in OFWAT to relieve what would otherwise be an obligation to have allowed revenue reduced to reflect the full extent of the supply failure from the water company, regardless of fault, because that is the default policy position.
Hold on, yeah. You wonder why they didn't say it, but there it is, they didn't, and here we are. Yeah.
We say it's not implicit, necessarily or otherwise, in the C exception that OFWAT will grant an exception to that general policy of no exclusions. And that follows from the fact that the obligation is to consider the representations. There's nothing express, or we say implicit, that the representations have to be accepted. And indeed, had the wording of a standard exclusion been used, it would have said, if the supply interruption is attributable to a civil emergency, with the caveat that you're not the cause of the emergency, and if you establish that the relevant supply interruption was therefore due to the civil emergency, then that will be excluded either by way of exclusion from the data that has to be fed in, or by way of exclusion from the calculation if you've got the data itself. And that would have been the logical way to draft this. I should say that I accept that this was based on the UK water industry report, but there was, what you haven't seen, there was a substantial debate at that stage as to the impact of severe adverse weather. And there was an Appendix B to that report, which left open for further debate between principally the water companies and OFWAT/the Environment Agency, what the consequences of that should be. So there was, the drafting was left in a state where the treatment of severe adverse weather events was not finalised as such. But OFWAT then adopted the reporting guidance with the default policy position that the drafters had put forward. Perhaps it might be worth turning briefly to that UK water industry report, because I've got a couple of points I need to make on the basis of it. It's in Supplemental Bundle Tab 6. It starts at page 115. Now, the first point is at page 116. It was a contractor, a consultancy firm that were responsible for drafting it. The specific authors are named, but one then sees at page 124, the top of page 124, the project was carried out by a team of consultants with specialist experience in the three areas under consideration. The aim was to build upon work by industry practitioner groups. Second paragraph, the criteria for assessing the reporting guidance proposed were discussed and agreed with the project steering group at the start of the project. These were then modified and expanded as we received feedback. So there was an iterative process of drafting. True it is that the main focus was on consistency, but we then see that at the bottom of the page, second paragraph from the bottom, the steering group itself comprised representatives from 8 water companies: Water UK, OFWAT, the Environment Agency, and CC Water. So it wasn't simply turkeys, and they weren't with respect to voting for Christmas. Its role was to ensure that both companies and regulators' views were taken into account, and that the process was seen as objective and transparent, and the outputs represented consistently.
How many water companies are there in all?
17, I think, of whom some have licences and a few don't.
There's 11 water.
Retail water. 17 under the price control regime, of whom 11 are water and sewage undertakers. So we then see that on page 125, essentially there was a process where a draft was circulated, said to be a straw man, but the straw man then received feedback and comments. Second draft was then prepared, full draft report was then prepared and given to the PSG for comment. There was then a presentation to the steering group summarising the approach, and that then produced the final report with the final key recommendations. So this report necessarily had to take into account not simply what's in the water company's interests, but also the countervailing views of both consumer-facing organisations, OFWAT and the Environment Agency.
And when it says our key recommendations, is that the project group or is it the 4 people who did the report?
That was the consultants' recommendations.
It's the consultants, right.
Which formed part of this report, which the steering group had nonetheless had an input into.
Yeah.
And no doubt if they vehemently disagreed, they would have said so. And there was, as I've said, there was a Appendix B to this report which outlined areas of disagreement, which you haven't seen. We then see that the draft terms, pages 141 and 142, are substantially the same, but they do not have the process flow chart that I've referred to. It follows from our analysis of exactly what the CE exception involves, that when a representation is made, OFWAT as a regulator will necessarily look at the representations and work out what its response to those representations is, and that necessarily builds in an element of discretion. And that discretion has to be exercised in accordance with the regulator's statutory duties. And my client's response will always be tailored to the representations it receives in the standard way. The decision to accept or reject those representations will be made on the basis of evidence before OFWAT and in the light of its statutory duties. That, with the greatest respect to my learned friend, is not a policy outcome. It's not setting a performance commitment. It's not saying at what particular threshold has to be met for a performance commitment. It's responding on a concessionary stroke relieving basis to a representation that the full impact of a failure to meet a performance commitment shouldn't be visited on the company. And I think before the judge in Leeds in September, I suggested it was not dissimilar from the sort of provisions one sees in taxing statutes for reasonable allowance or for a reasonable excuse from what would otherwise be the consequences of a failure to pay tax on time by way of a penalty that would otherwise be imposed. And so if I don't say it's appropriate to say an underperformance adjustment of revenue as a penalty as such, it simply reflects the bargain that the company has entered into with the regulator when it says we will hit this target, and if we don't, we'll pay customers something back, and if we exceed it, customers will pay us something for the benefit of doing better than we said we would. And that's part of the bargain that the water company selects every 5 years as to what commitments they are going to meet when it's the bespoke commitments. The common commitments are set with all of the water companies in mind and pursue a common framework.
And the risk is, in you saying the bargain, that they'll be done for the lot, the performance undertaking, but they've got the chance of persuading you in a plea of mitigation, yes, I shot her, but you should have seen what she was doing to me, effectively.
Similar, my lord.
Yeah.
Similar. Maybe not legally similar, but yes, metaphorically similar. Now, the policy intention behind this, if anything, is the policy intention that's spelled out on the face of the reporting guidance itself, which is there will be no exclusions. So that is the policy. The policy is we don't care whose fault it was. If you don't supply, you don't get money for supply. And if one is seeking to mimic, I think that was the word you used, the market, which commercial company gets the benefit of failing to supply its customers as a result of an act of God, call it a storm, and doesn't have to suffer the consequences of doing so? And the answer is every company has to build in a risk assessment of what adverse factors will impact on its business and develop a business plan accordingly.
But the policy isn't absolutely that there's no exclusions, because there is the possibility at the very least of an exception. So you must have had something in mind. And the question is it absolute or is it discretionary?
Yes, I accept that. We wanted to leave open the possibility for water companies to say that they shouldn't bear the full brunt of what would otherwise be a dramatic underperformance in the context of a civil emergency. And it's not just about weather. It could be a serious terrorist threat. It could be the London riots. It could be whatever civil emergency one looks at over the last 20, 30 years. My learned friend's quite right that I made forensic play below, and it's in our skeleton, of the 192 pages on the National Risk Register of the type of civil emergencies that might arise. You then have to multiply that by the 17 companies that are under the statutory price control and work out, on his case, a policy for each of them, which he says we should triage the important ones. It's difficult to know. Nobody expects the Spanish Inquisition, but one can expect a terrorist attack, one can expect a severe adverse storm that will cause a civil emergency. One can also expect any number of civil emergencies, from rioting, disorder, poll tax riots. One need only delve into recent history to find examples. But to have a policy that leaves some off the list, with respect, makes no sense, because then one falls into the problem that if, exceptionally, one of those other risks arises, well, we haven't got a policy to cater for. And that's deeply problematic. Now, in terms of the overall structure, I would like to briefly take you to Miss Armstrong's witness evidence that was before the judge. It's in Supplemental Bundle 3, starting at page 65. Could I invite you to read, please, paragraphs 23 to 25 first.
Pages?
Page 65 to 66 of Supplemental Bundle tab 3.
Before we get there, can you just put me out of my misery? Why does Miss Armstrong say at paragraph 7 it's a non-ministerial government department? It's not, is it?
It is. It is. I can come back to you.
Okay, don't worry. But
on that. But,
that's right then.
Yes. I sent a message back. I haven't had a response back yet.
Don't worry. Yeah. You want 65?
Page 63, please, to 64. Sorry, you're right. Sorry, 65 to 66. Paragraphs 23 to 25.
Yes.
And then, please, page 67 and 68, paragraph 28, Miss Armstrong makes the point I've just made, which is that if there was an intention to give an automatic exclusion, this would have been set out expressly. At paragraph 29, she says, this performance commitment does not stipulate that any further step must be taken in order to exclude these items. So she's giving the example there of the mains repairs performance commitment. So that is an example of an automatic one, and no representation needs to be made.
And that's a no report.
That's a no report one. And then 30, I consider that the automatic approach was not taken for the CE exception because it's in the nature of civil emergencies, but they are highly unusual with potentially wide-ranging causes and widely differing impacts. In such circumstances, she says it's no surprise that the reporting guidance confers a broad discretion. So that's part of the motivation behind the different drafting that one sees. And the point, I'm at risk of repeating myself, is to allow a safety valve from what would otherwise be the full rigour of failing to meet a performance commitment in a given case. while I have Miss Armstrong's evidence metaphorically open, would you please also look at page 79, paragraphs 65 to 67, where she says in terms actually physically drafting a policy of the sort that my learned friend would have my client draft is not going to be necessary, appropriate or practical. And she says at paragraph 65, the nature of a civil emergency can vary significantly, and how companies perform against or are affected in such situations can be influenced by a wide range of factors. As such, it would not be desirable nor practicable for Ofwat to provide a policy for every single possible scenario. It would not be possible to predetermine what civil emergencies might arise or what the response should be. She then points out that there are certain safety valves in the conditions themselves, and I'll come on to address you on the conditions probably now, first thing in the morning. But there's a provision for substantial adverse consequences of a change of circumstance and also substantial favourable changes in favour of the water company. So condition 14 and condition 15 in B actually enable, once you reach the materiality...
Suppose, for example, a water company got into commercial difficulties during a 5-year period. Is that a situation that might give rise to an adjustment?
If there was an underlying substantial change in circumstance, which meant that the ability of the water company to finance its business was in jeopardy, and that would have a knock-on impact on consumers,
yeah.
Yes, it would be the sort of thing...
Right, so take another, maybe related, maybe unrelated example. But when we come to the point of in exercising the discretion that you claim, what factors are relevant to it? I mean, clearly performance is one, if not the main
yes.
issue. But let's suppose you were dealing with having to do a civil emergency exception judgment in regard to 2 different water companies, one of which was failing and facing the brink of continuing in operation, whereas another one was thriving and burgeoning. Is it your interpretation of your powers that those are relevant factors that you might wish to take into account, considering the overriding objectives, including resilience, for example?
Well, I think because the part of the balancing equation for the 4 principal duties that relate to water retail would be the finance condition. It would be impossible for my client to exclude from consideration the ability of the water company to finance itself if the adjustment would be so high that its very economic viability was threatened.
So the answer to that question is in principle, yes.
The answer is it would be a relevant consideration. It wouldn't be a determinative consideration because it would need to be part of the panoply of factors that were taken into account.
But because you're concerned not just to see a fair outcome in relation to a particular adverse event, but also with the wider picture of the continuity of service and the interests of customers generally.
I think that the statutory overlay would permeate whatever decision was taken, and the statutory overlay requires sometimes considerations that are in tension with one another, as the judge recognised, to be reconciled. And it's the job of my client as an expert regulator to reconcile those competing
But it's theoretically possible, according to your scheme of things, that you could have 2 neighbouring water authorities who had the same sort of client base, both be hit by the same storm, which was a civil emergency, but for reasons which it would no doubt have to spell out, relief was granted to one to a much greater extent than to another.
I accept that's theoretically possible. In practice, my submission would be it's unlikely. But
what do you think it might be? I mean, for political reasons or something of this sort, it might be quite difficult. But legally speaking, your submission leads to that conclusion, doesn't it?
It does.
Yeah. Right.
It leads to the theoretical possibility. But it leads to the theoretical possibility on the basis that my client is not open to my client as a creature of statute to do anything other than comply with the obligations that have been imposed by Parliament. And Parliament has said to my client as a creature of statute, you will take into account the following 4 principal duties, one of which is the finance condition, which would go one way. The other is ensuring that services are delivered properly by a water company, which would pull in entirely the opposite way. And there would be no way of reconciling that, in the same way that the resilience objective would suggest that the water company should be held to account for its failure to build a resilient network. But my client might take the view that the consumer objective would be better served by ensuring that you didn't have a water company go into insolvency, for example, leading to a wholesale failure to provide an entire water area with water. What I don't think we do have in the water industry is the sort of emergency insolvency procedure that one finds in the electricity sector. Well, we do. I'm sorry. I was about to misstate the position. So I think everything I've just said is necessarily predicated, therefore, on the fact that there are statutory provisions in place by which an ailing company can be helped. But nonetheless, as a matter of principle, unless anyone tells me I need to wind my neck back in, I think my Lord's point is absolutely right. As a matter of principle, because those 4 duties have to be taken into account, it could potentially lead to that situation. So, as for my overview on ground 2, therefore, the reality is that following Miss Armstrong's evidence, one's simply not in a position to provide a detailed, sensible, written policy in advance as to how the discretion should be exercised. What the legislative scheme does do is very strongly steer my client as to how they should exercise their powers, i.e. consistently with the duties and consistently with the objectives that are identified. But the reality is that that can't be circumscribed in advance, and indeed public law would say that my client would have to consider representations that were made to it in this field, even if they weren't related to performance-related issues. So my client would be under an obligation to consider whatever representation was put in, even if it wasn't strictly related to either a civil emergency or anything else. And that's just the nature of the public law beast. Obviously, my client's response may well be this is irrelevant, or we're not going to take it into account, but it will at least have to consider the nature of the representation and deal with it. Now, it's important to emphasise that this case actually is not about performance as such, it's about underperformance. And the representation that was made by Northumbrian was a representation for it to be relieved from the full extent of its commitment. So it was akin to a waiver of the full impact of its underperformance when measured against the specific metrics in issue.
Would you like to choose a convenient moment? I'm very sorry to everybody that it's so warm in court. We'll see if anything can be done about that tomorrow. But choose a point where you're comfortable to pause.
Might I just please finish with a couple of background policy points?
Certainly.
It's right that the challenge decision here amounts to a decision to share equally the impact of Storm Arwen between the water company and its customers. But that must be seen against a background policy developed by OFWAT over several years. Firstly, that water companies should bear the risk of adverse weather events, since they're better able to assess that risk and take steps to minimise that risk. They're in a much better position to do that than consumers. Secondly, the regulatory settlement between water companies and consumers was dealt with at PR19 and was endorsed by the CMA on a redetermination. And that is that there are generally no exclusions from the ODI criteria. That's the policy framework. And it's for that reason that exclusions are clearly demarcated in the regulatory guidance or the terms of the performance commitments themselves. The CMA actually, in the redetermination, allowed the businesses more revenue than they otherwise would have done. They changed some of the funding requirements so that they could bear better the greater risk that was being imposed on them by the regulatory settlement. The PR19 package represents a broad balancing of the risk and reward amongst a host of different outcome-based criteria, and it necessarily reflects the switch to outcomes-based regulation. So when companies made their investment decisions following PR19, they would have known that the primary policy position was that they would bear the risk of events, including severe adverse weather events, and that OFWAT's position was that it mattered simply whether or not the metric was met, and that the blame game was a thing of the past. That allocation of risk is then linked to the final formulation of the performance commitments, which were approved by the CMA. That, my lords, my lady, is probably a convenient point at which to
Thank you, Mr.
pull up stumps.
Can we look into tomorrow then? How long would you expect to be?
Well, I'm hoping to be finished by midday.
Assuming that we're going to be rising by 12:30, does that give you sufficient time to reply?
I will cut my cloth accordingly, my lord. If that's when you must rise, that's when you must rise.
No, we could rise at 12:45, but we can't rise at 1 tomorrow for particular reasons. So
12:45 from my perspective, I have to be candid, would be preferable.
right. Well, shall we work to that then? Yes. Thank you very much.